Hello again. This video lecture covers Chapter 3. The title of the chapter is Functions and Sources of Law. This is from the Introduction to Paralegal Studies, a Critical Thinking Approach textbook, the 5th edition, written by Currier and Eimermann. A quotation from the Declaration of Independence: "We hold these truths to be self-evident." In this chapter, Part A is covering the functions and theories of law, and Part B is covering the sources of law. This chapter will familiarize you with, or refamiliarize you for the most part, with some of the areas that you may have already learned before in a civics course or an American government course. This will take us on a short tour of that, and in relation to the paralegal profession, or the legal profession in general. The usual warning: this is a presentation. It's a video lecture that covers the textbook. However, it shouldn't be the only source you use as a study guide in preparing for the quizzes or tests in this course. First of all, let's look again at the definition of law. As noted in the textbook, law is a set of rules of conduct that are promulgated and enforced by the government. As you'll learn today, and you probably know again already, that different governmental branches create the law, and that governs conduct. The function of the law is to define the rules of conduct for the people that live within or visit within the state that they are visiting or living in. And importantly, the function of law is so that there is some order and predictability. And so we have the functions of law as listed here. Sources of law. When you're asked to evaluate, I should say analyze, as we've been learning in the prior chapters, a problem that a client faces, you're faced with asking, okay, what is the law or the authority that governs this type of problem? Is it something that a legislature would be involved in making laws that affect the conduct of people? Or would it be something from the executive branch of government, or perhaps the judicial branch? All three branches are involved in making the law, and there is, of course, an interplay among them that gets briefly discussed in this video lecture as well. First and foremost, we need to look at one of the sources of law that is commonly the one that we begin with in a conversation about what are the sources, is constitutional law. Constitutions are a body of principles and rules that are either explicitly stated in or inferred from the constitutions of the United States and those of the individual states. So recognize from this statement made in this particular picture that we have the United States Constitution and we have a constitution of each of the 50 states. Constitutions are more of a prescription of body of principles that apply to how a government is structured. And also, as we know from constitutional law, have a large role in what the state, as in the United States government or the state governments, can do to regulate the conduct of others. This next slide gives us a little bit more insight to this. The functions of the United States Constitution, as I've already noted, establish an organization of the government. In our Constitution of the United States, the federal government is divided into 3 branches. We call this a separation of powers, as well as a system of checks and balances. There are the first 3 articles of the United States Constitution set out this federal government and these three branches. Notice that Article 1 of the United States Constitution is that which empowers the legislative branch. If you have a copy of the United States Constitution in front of you, actually in your textbook in one of the appendices in the back, you can look at the Constitution as you're reading, because it's a good idea to be getting a feel for what these sources look like as you're using them in the course. Article 1, Section 1, I'll read verbatim. Section 1 says, all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. And this is exactly what you are noticing when you listen to the news about the media, about what's going on in the legislative branch of the United States government, and that would be Congress, that has the two both the Senate and the House of Representatives. Each one, the Senate and the House of Representatives, having their own obligations as far as what their powers are. The executive branch, if you turn to the United States Constitution, Article 2, the executive branch is established in Article 2, and Section 1, subsection 1, so Section 1, sub 1 of Article 2 establishes that the executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years, and together with the Vice President, chosen for the same term, be elected as follows. And then subsection 2 explains how the election will take place and how the Electoral College is set up. In other words, all of this is established through the United States Constitution. It's not something that was made up by some office of people just saying, let's have elections should work like this. And that's why we refer back to the Constitution as a source of law when we are asking, does the executive branch have this power? How is the executive branch brought into being, and how are the elections had? Article 3 sets up the judicial branch. In the United States Constitution, Article 3 reads, Section 1, the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and the inferior courts, shall hold their offices during good behavior, and shall, at stated times, receive for their services a compensation which shall not be diminished during their continuance of office. And then it goes into Section 2, 3, etc. The United States Constitution does. You can read those, and as I pointed out, this is how our United States Constitution has empowered each of these three branches, and that because of the three branches and the separation of their powers, we're able to have checks and balances. Okay. Now, along with that is the concept of federalism. And the United States Constitution sets out a minimum of criteria for the power of the United States government. And federalism, which is actually, they have a definition in our textbook, on page 48 reads, federalism is a system of government in which the authority to govern is split between a single nationwide central government, that would be our United States government, and several regional governments that control specific geographic areas. That is what the division of power between federal and state governments is like in America, with the United States government as a nationwide central government, and all of the individual 50 states as regional governments that controlled their own specific geographical areas. And the textbook does not, on chapter 3 anyway, does not really emphasize this particular point well. And that is, the 10th Amendment is what brings federalism into being. It brings this concept of, what is federalism and how did we get to the point of having federalism in the first place? Well, it's the 10th Amendment of the United States Constitution that specifically reads, and it's the title of the 10th Amendment is Powers Retained by the States and the People. The powers not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states respectively or to the people. In other words, this division between federal and state governments, the concept of federalism, is brought about by Amendment 10 of the United States Constitution. And you can read Amendment 10 in that copy in your appendix. And the concept of the Bill of Rights was to, and is to, protect individual rights from governmental overreaching. Because if all of the federal government had too much power, then the federal government would be able to control too much. Just as the individual rights of the states are left to the states by the 10th Amendment, that protects the states from having too much of the central government overreaching into the state government's lawmaking. So the functions of the United States Constitution are set out there, and you would find, by the way, that most of the constitutions of the United States have very similar organization, and the same thing is expressed in your state constitution as in the United States Constitution, keeping in mind that the United States Constitution sets a threshold, and the states can actually give their citizens more rights than the United States government has given. And again, that 10th Amendment delimitates the powers that the states have. They can't go, if they're prohibited from giving certain rights to people because of the Constitution, then Amendment 10 says the states can't legislate or make laws in that area because it's already been reserved to the United States government, the Congress, for example, or the judiciary of the United States. And then some of the powers are actually explicitly delegated to the states in the United States Constitution. A little bit more of that will develop through the rest of these slides. All right, so next, separation of powers. The discussion we had about federalism is, the discussion about separation of powers is about dividing the government among the legislative and the executive and the judicial branches, so that no one branch has too much power. Checks and balances, and again we're still talking about the United States Constitution, is the example of how the division among governmental branches not only separates the powers but creates a balance of power among the three branches, so no one governmental branch has too much power. One other thing about the United States Constitution that comes into the discussion is called the power of judicial review. The United States Constitution specifically grants power to the United States Supreme Court to review statutes to decide if the statutes conform to the federal or a state constitution. And the power of judicial review also extends to the states, because state courts have the power to review their own state statutes to decide if the statutes or other type of law made, maybe the executive branch or an administrative agency, has the power to review those is making constitutional law. So if you are listening to the news so put this into perspective. If you're listening to the news or following a problem that you think is important, and you hear that the United States Supreme Court has said that they're going to review a case that looks at the statute. We recently had same-sex marriage in the past couple of years, always on the docket of the United States Supreme Court. When the United States Supreme Court, members of the United States Supreme Court decide to hear a case, that means they're going to review to see if the outcome or if a statute, for example, is in conformance with the federal Constitution. If our Florida Supreme Court decides to review a case, they would be doing the same thing. This is what judicial review is: one body looking at it from a legal perspective to see if what that statute, that legislation, that would be a statute, what that legislation says is what the law that is made, if that law is in fact conforms to the Constitution. So that's the power of judicial review. And by the way, there is a film in the course that I set up on Marbury versus Madison, and Marbury versus Madison is mentioned in the textbook, and it's a very, very important, very, very important case for you to have some understanding of, so please make sure that you watch that to help improve your understanding of judicial review. I mentioned federalism already. This is that exact quotation, I should say, from the textbook on page 48. Federalism is a system of government in which the authority to govern is split between a single nationwide central government and several regional governments that control specific geographic areas. The Bill of Rights are the first 10 amendments to the United States Constitution. The 10th Amendment I already explained to you earlier. I mentioned how that 10th Amendment is titled Powers Retained by the States and the People, and if the power is not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states respectively or to the people. So 1 through 10 are the first 10 amendments to the United States Constitution. Of course, over time, the United States Constitution has been amended, or I should say the Bill of Rights have been amended, and you can look in your copy of in the appendix and see that it's gone all the way to amendment, 10, 25, 27, which concerns congressional salaries. All right. The Doctrine of Incorporation is a constitutional law concept, and the application of the 14th Amendment's due process protections to incorporate the provisions of the Bill of Rights and make them applicable to the states. And if you look at Amendment number 14, which was proposed on June 13th, 1866, and ratified on July 9th, 1868. And it extends the protections of the states to all people. The Bill of Rights to all states. In other words, I mentioned earlier, the states can make their own laws that affect the rights of the state's citizens. But the 14th Amendment, among other things, sets out that the provisions of the United States Constitution's Bill of Rights those amendments to the United States Constitution are also applicable to the states. In other words, this central government is more or less decentralized and sent to all, and the laws of the Bill of Rights apply to all states because of the 14th Amendment. And it did not apply to all states before the 14th Amendment. The significance of that is that the states can't make laws that are unconstitutional any more than the United States government can't make laws that are unconstitutional. Enough said about that, but I hope that makes sense. Okay, so that's the 50-cent tour, I guess you might say, of the United States Constitution. That it sets forth a system of government, creates checks and balances, and the 10th and the 14th Amendment are really important amendments to the Bill of Rights that you would want to feel pretty secure in understanding at this point, on a very general level of understanding. Now, the next source of law to cover is statutory law. Statutory law is law enacted by a state legislature or Congress. Statutes, as we call them, are set out by legislatures, either the United States Congress or by the state legislature, and they control conduct. They'll specifically delineate: you can't drive your car on the left-hand side of the road. You drive on the right-hand side of the road. Statutes are, they govern future conduct. In other words, if the Congress or if the state legislature makes a statute, then from the date of the enactment, or the effective date, I should say, of a statute and forward, then all citizens need to control their conduct according to the statute that's been made. Statutes are sometimes, we'll talk more about that in the classification of law, but statutes, like I said, are meant to control future conduct, and they're from that branch of the government that's the legislative branch. Another area that is not mentioned in the Constitution, and I don't want to confuse it too much, but another area of law, source of law, that's included in any conversation about the sources of law is administrative law. Administrative law are rules and regulations that are created by administrative agencies. Administrative agencies are empowered by legislation. An example of how this could have been, instead of having administrative agencies, and let's list a couple. Equal Employment Opportunity Commission, that's an administrative agency. Child Protective Services in Florida, that's an administrative agency. EPA, Environmental Protection Agency, that's an agency, and the state has them, and the federal government has them. Administrative agencies are actually created by legislatures. Back in the day, when our country was first founded, the administrative agencies were not in existence, and this is because Congress, with the United States being so new, Congress felt that they could manage all of these smaller areas of specific problems. Patent office, they felt that, we can do that. We'll be making law, but we will also be able to handle making rules and regulations that apply to patents. And what Congress realized a long time ago is they could not do that. There was not enough time in the day. They were taking on too much. And as a result, there became administrative agencies that were created by the legislatures, either Congress or the states, and said, look, you now, let's say the Environmental Protection Agency, We're going to create, says the legislature in a statute, we're going to create an agency called the Environmental Protection Agency. And that enables the person to have that enables the agency to do the job that they are asked to do by the legislature. So that's an administrative law as a source of law. Agencies make rules and regulations. They create them. Rules are made through public comment. Regulations are made typically by the agency that governs more of the conduct of the people who have to utilize the agency. And if I were to choose an example, I think the Social Security Administration. The Social Security Administration has a lot of obligations to the people. They pay retirees. They also facilitate claims for disability and claims for Social Security. And to do that, and they have a set of rules that say, you're entitled to Social Security disability when you meet this criteria, and it's set out A, B, C, D, E, and so forth. And then administrative agencies then their regulations say that, well, if you want to make a claim, you make the claim in this way. You fill out this form, and it has the you can and you can'ts after the fact or during the process of the claim that a person is making. So there's a difference between rules and regulations, but again, right now we're really in the cluster of the administrative law and the agency powers. This slide is sources of law as it applies to the judicial branch. The judicial branch, as we've talked about, it's included in the United States Constitution, and each of the 50 states have a judicial branch, and they are their sources of law come from opinions, decisions, cases. Now, this is important to emphasize. These three things are in the judicial realm of a source of law. They're all the same thing. All right. Opinions are written decisions about cases that have been made by the judicial branch of the government. The judicial branch has several powers. One of them is they can interpret constitutions, statutes, and regulations. In other words, these sources of law that I've already covered earlier, they are all subject to interpretation by the judicial branch. And when they interpret, they write down their interpretations, and they put them in opinions, decisions, or cases. And they're written rationale and reasons for why the court made the decision it did in interpreting the Constitution, the statute, or the regulations. In addition to interpreting these sources, the judicial branch can also create and modify common law. Common law is what is known as court-created law. And common law came about when, at a time when there was no when there was no law to explain what was the law. If we don't have a constitution or a statute or a regulation, we turn to common law. Common law is, some very ancient type of law. I mean, killing people has been illegal for many, 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 many centuries because it's just wrong. Common law also has a history of being brought by judges because what happened was it came from England. So it actually started with the Norman Conquest. That's where the idea of common law came from. And we carried this through from even as far back as the Norman Conquest in Europe. Judges then they went around from circuit to circuit. In other words, they went from town to town, and village to village, and they would listen to a case and hear the arguments of people, just like we're doing today. And when they made a decision, they got together later as a group of judges. They had a little conference, if you think about a little conference room or something like that, and they sat down and said, in Village A, 2 people had a dispute about their land, and one of the persons was landlocked, and this is just an example, and the person who was landlocked needed to cross the property of the person who wasn't landlocked. It was the only way to get to the property. And the judge is saying, I listened to their arguments, and I decided that the person who was landlocked was entitled to a right of way across the other person's property. And so I created some law. This decision is something that we should, for the sake of predictability, in all cases that are like this and have similar facts, we should be doing the exact same thing. And they all agreed, said, okay, we think that's true. If someone is landlocked, there should be a natural right of way for the person who's landlocked in their property. That is just one of a billion examples of how common law works. It is this way because commonly it was decided this way, and it's common in all cases of similar fact. And in a minute we have another slide on that, so I won't take it any further until then. But in the meantime, this chart that's come up next is a nice little layout of the sources of law. How we have the federal government areas right here, which include the United States Constitution, Congress, agencies, and court. Remember that the Constitution also deals with the executive branch, which the executive branch does have some lawmaking authority. But if you go across this way, you can see the type of law. Constitution, we have a federal. Each individual state has a constitution. Here's another type of law: statutes, laws, resolves, and codes. These are just terminology, different types of terminology for what is really technically a statute. Different states might use different terms, but at the end of the day, what we're dealing with is either Congress on the federal government level or legislators on the state government have made laws, and we tend to call those statutes. The book does want us to understand that some other names might be used, like codes is pretty common. Regulations and rules are a type of law. Remember, those come from agencies, and we have them both from the state and the federal. Opinions, decisions, and cases. Remember, that's statutory interpretation or common law that comes from courts. And look, we have the courts on the federal and the state. I think one of the most important things to take away from this is the fact that down this center column, we have all these types of laws, but you need to recognize that they're made on both the state and the federal levels, that is. And the significance of this will be more pronounced when we move through the course and even into legal research and writing. But the next chapter, chapter 4, we start to look at, is this a federal law or a state? Is this problem that the client walks in the door with governed by a source of law that's federal or state or both? And so without getting too far ahead of the game, chapter 4 will take us even more into this. So this is an important little chart to help to illustrate for you how laws come from both. All types of laws have origins of federal or state or both. Back real quick to common law. Remember I told you common law is laws created by the courts, and that courts interpret and apply common law when no statute, regulation, or constitutional provision will govern. And the doctrine of stare decisis is a Latin term. Stare decisis means that normally, once a court decides one way on a particular issue, that court that is, and other courts in the same jurisdiction will decide the same way on that issue in future cases given similar facts, unless they can be convinced of the need for change. And so I take you back to that example I gave of, back in the old days when the judges came together after riding the circuit, they called it. They would ride the circuit because of course they had horses and buggies to get them there, so they would ride the circuit. They would go from town to town, they would resolve disputes, and for consistency into the future, and they would share with each other those decisions, and they would expect that everyone in that circuit would decide the same way in future cases if the facts are similar. And also the term that comes up here in a little bit, we get into this even more in chapter 6, is jurisdiction. And what that means is, a jurisdiction is a form of power. And for example, let's say that back in the days when they were riding the circuit, there was Circuit A, Circuit B, and Circuit C. Well, Circuit A and all of the courts within Circuit A are in the same jurisdiction. Circuit B and all of the courts within Circuit B are in the same jurisdiction, and C, and so on and so forth. But it's possible that Circuit A and Circuit C, or B and A, have different outcomes. Different decisions have been made over time in one circuit versus the other. And so the idea is that with jurisdiction, when they're in the same circuit, they want to decide the same way on the same issues in future cases. And that's the idea that we call stare decisis, which is a Latin term meaning let the decision stand. That's what it means in Latin, or in English. As noted earlier, the judicial branch of the government, they interpret the constitutions. Constitutions are written, some of them a long time ago, and it can be very hard to understand what the founding fathers meant by freedom of speech. And so what the Constitution means, what it says, is one of those interpretation areas left to the United States Supreme Court, and if it's trying to interpret the state constitution, the state Supreme Court. So people bring their problems and they go through the state court system or the federal court system. Eventually the outcome may be that the courts have interpreted what the constitution of the state or the federal government means. Interpreting laws created by legislature agencies and the agencies. This is also, again, we don't always, I can't tell you how many times I've read a statute being something, a law that is made by a legislature, and asked myself, what does this mean? And I can turn to cases on the judicial branch that explain what the statute means. And statutes, constitutions I've mentioned already, I mean, it can be hard to understand what was meant by a clause in a United States Constitution. We may not know and until it's tested or interpreted by a court, we don't know. They're the ones that'll tell us. Laws created by the legislature can be poorly drafted, or they may intentionally be vague and ambiguous because the legislature, wanted the law to apply to lots of different circumstances. And remember, we're always looking for consistency in the law. So if like situations come about, in fact, and they're interpreted by the court, they'll be interpreted the same way over and over again, unless, like I said earlier with stare decisis, unless there's a reason to change that interpretation. So the vagueness and the ambiguity of the legislation may bring it to the courts to decide how should this be interpreted. Agencies, the same kind of thing, that agencies also have the same issue where their rules or their regulations are often hard to understand, not clear what they meant. So the judges can to interpret what they mean. And the common law, and we talked about common law. The idea is to maintain consistency, predictability, and so interpretation of the common law is also done by the judicial branch. When people bring their problems to the court, the common law is subject to interpretation. What also I want to add while we're on this point is that oftentimes the legislature, and they have this on page 54 of your textbook, the legislature will sometimes codify the common law. And on the left margin of page 54, it talks. There's a definition. It's called codification of the common law, which is the process of legislative enactment of the areas of the law previously governed solely by the common law. So, backspace in time to the day when the judges who decided trespassing it wouldn't be trespassing to take a common easement across a person's yard if the person crossing the yard was someone who was landlocked, and the only access to their yard would be through that person's yard. Over time, the legislature of the state eventually says, this is common law, folks. We've been doing it this way forever and ever. And so we're going to make a law now, and we're going to put it in statutes. In codification, if you will, pronounce it that way, either way works. Codification of the common law is saying, this is how we've always done it under common law principles. The legislature says, great, we're just going to incorporate that into our statutes. And that way we don't have to refer to common law anymore. It's now legislation. But let's say common law said, let's pick something ridiculous. Let's say that common law said, and over time, people could only cross over the property if they had a rope. That the only way, according to common law, to not be guilty of trespassing someone's property, when you're trying to get to your property because it is landlocked by someone's property, but you have to swing on a rope. And common law, that's the way we've always done it. Every judge is going to decide it that way. Forget it. And then finally one day somebody says, that's crazy. Why should a person have to swing on a rope from point A to point B to get to their property? Let's say that as long as they don't disrupt the property that they're crossing over, as long as they, clean up their breadcrumbs as they cross over it, then it's okay. And that's different from what common law said. Common law said you have to use a rope. The legislature comes along and says, okay, that's it. We're not going to do it that way anymore. We're going to codify this in derogation of common law. And if you look on page 54, right underneath the definition of codification of common law is the definition for derogation of the common law. And it's used to describe legislation that changes the common law. Make sense? I thought so. Let's see. Let's see if there's another slide. If not, in conclusion, this is a great slide really to end with, and just as a reminder of how there are the different types of law, different sources, and each of these are sources of law. And again, all of these have some federal influence as well as some state influence. In Chapter 4, which is going to be a separate video presentation, there will be a little bit more to expand on how these are considered they're classified from state and federal, civil and criminal, etc. The purpose of Chapter 3 was to help you to gather a good understanding of, a general, I should say, understanding that rules of conduct, they're enforced by the government, and we have our country and our states that are organized by constitutions. We have within those governments different bodies, different branches of the government, the legislative, the executive, and the judicial, and each of those bodies, those branches of government, make the laws that you're talking about. And those branches are either court, agency, Congress, or the Constitution in the federal level, or the branch of the individual constitutions, the state constitutions, and the branch of the legislature, the agencies, and the courts. Not a lot goes into this chapter on the executive branch, but in the news today, that has been the executive branch's ability to make law has been a big, a lot have been talking about it. President Obama making some executive orders and that sort of thing that, is one way of circumventing Congress's powers. And so, there is an example of what we're talking about with executive branches making a source of law. All right, so thanks. Move on to Chapter 4, and I highly recommend that if there are any supplemental materials brought into this chapter that you that I've provided in the course, that you take a look at them. They can enhance your knowledge and give you some ideas of things to use in the future.